Let's take a look at property law practice.
Power of attorney. According to the Supreme Court in Ude and Owara 1993 to Nigerian Law Report Part 273 at 638, a power of attorney is a document usually but not always necessarily under seal where a person seized of an estate in land in this context called the donor authorizes another person called the donee to do instead of the donor anything which the donor can do lawfully. Essential features of a power of attorney. A power of attorney mirrors an agency relationship but is sui generis and differs from other commercial agencies. The person who donates the power is called the donor. The person to whom the power is donated is called the donee. A power of attorney is a document that must be in writing. Abina Farad, 1938-14, Nigerian Law Report at page 17. It is an instrument of delegation and not an instrument of alienation. Thus, it only serves as an instrument that enhances alienation of interest in property. Ude Anwara 1993 to Nigerian Weekly Law Report Part 273 at 638. It does not alienate or transfer interest in land. Amadi and Nasirim 2004 17 Nigerian Weekly Law Report Part 901 at page 111. Ezigwe and Awudu 2008 11 Nigerian Weekly Law Report Part 1097 at page 158. Although a power of attorney must be in writing, it need not be by deed. However, where the power of attorney is given to do an act which must be done by deed, then that power of attorney itself must be by deed. The power of attorney is not mandatory in land transactions. However, there are circumstances that may require a power of attorney and they are listed as follows: unavailability of the donor, physical impairment, and the need to involve an expert, e.g. lawyers by virtue of their knowledge of the law. A power of attorney must be given by a person with legal capacity to another with legal capacity. It cannot be used to cure a donor's disability. A power of attorney may be revocable or irrevocable. It requires a fixed rate of stamping and usually the registry assesses the document per value of the consideration offered. A power of attorney does not require consent provision since it does not transfer interest in land. The powers conferred on the donee may be general or specific, revocable or irrevocable. Specific power of attorney, where the power is given in respect of particular acts to be done by the donee of the power. A perfect example is letting out properties to collect rent. General power of attorney, this occurs where powers are given to the donee to cover a broad spectrum of issues pertaining to the subject matter. Revocable power of attorney, this kind of power can be revoked at any time and for any reason so long as the donee has not exercised the power. A revocable power of attorney, this is one which is given for a consideration and also coupled with interest. It can also be for a fixed period not exceeding 12 months. During this period of 12 months, the power given to the donee cannot be revoked. How is the power of attorney created? The mode of creating a power of attorney depends on the purpose the power of attorney intends to serve. Marijuana 5-Star Limited 2002 to Nigerian Weekly Law Report at page 1. Where the power of attorney has to do with land, it must be in writing to comply with Section 4 of the Statutes of Fraud Act 1677. If the power of attorney is for a purpose of executing a deed, the instrument authorizing him must be by deed. Powell and London and Provincial Bank 1893 2CH 555. Conditions for the validity of a power of attorney. 1. For a power of attorney to be valid, both the donee and the donor must be legal persons. To this effect, only a juristic person can sue and be sued. 2. Only a juristic person can give a power of attorney and be appointed as a donee of a power of attorney. National Bank of Nigeria and Common Brothers Nigeria Limited and others, 1976 1 FNLR 116. A person under any legal disability cannot donate or be appointed a donee of a power of attorney. Examples of such persons are lunatics, infants, and bankrupts. If the authority relates to land, the donor must be the owner of the land and must also have the capacity to carry out the acts which he authorizes another to do in his stead. Thus, the appointment of an agent cannot be used to cure the disability suffered by the principal. Ajunwon and Adeoti, 1996, Nigerian Weekly Law Report, page 132. More often than not, the power of attorney is usually executed by one party. However, it can be executed by two parties where the donee has obligations to perform. Here, the donee needs to sign to show that he accepts such obligation. A power of attorney made as it is registrable, UBA and Registrar of Titles. Non-registration of the power of attorney renders it inadmissible in evidence. Section 15 of the Land Instrument Registration Act.
Let's take a look at the distinction between the power of attorney and the conveyance. For the power of attorney, the parties are referred to as the donor and the donee. For the conveyance, the parties are referred to as the vendor and the purchaser. The power of attorney does not transfer interest in land. Conveyance is used to transfer interest or title to land. Except in Lagos, governor's consent is not required for a power of attorney, but for a conveyance, governor's consent is mandatory. And for this purpose, see the authorities of sections 21 and 22 of the Land Use Act. A power of attorney is usually executed by one party, thus making a deed poll. For a conveyance, it is usually executed by two parties, thus making the deed indenture. A power of attorney is an instrument of delegation. A deed of conveyance is an instrument of transfer or alienation of property. For a power of attorney, it does not require any special mode of creation except it relates to land, and this is for the sole purpose of complying with Section 4 of the Statutes of Fraud Act 1877. But the conveyance must be by
Difference between the power of attorney and the conveyance. 1. The power of attorney need not contain a recital, but the deed of conveyance must contain a recital. 2. A power of attorney may or may not be revocable. A deed of conveyance is not revocable except if delivered in escrow and the condition could not be fulfilled. 3. A power of attorney may be executed in respect of any subject matter, while a deed of conveyance must be for an interest in land. 4. The donee cannot sue in his own name but in the name of the donor. Melania and 5 Stars Limited 2002 Nigerian Weekly Report Part 1. While in a deed of conveyance, any cause of action can be instituted in the name of the parties. Difference between power of attorney and a contract for the sale of land. A power of attorney does not transfer interest in land. A contract for the sale of land transfers equitable interest in land. A power of attorney is usually executed by one party. A contract for the sale of land is usually executed by two parties. A power of attorney necessarily need not be exchanged between the parties for it to be valid. A contract for the sale of land must be exchanged between the parties to be valid. A power of attorney does not necessarily attract stamp duty but attracts a fixed duty. In a contract for the sale of land, there must be stamp duty that is usually assessed ad valorem. Section 28 of the Stamp Duties Act.